welcome to our podcast, Privacy Chats with Rachel and John. John and Rachel.
Hi, Ray.
Have we decided that yet?
Rachel, John, Rachel, it doesn't matter. It's the two of us.
Sweet. Well, I imagine all you are new because this is our first episode, and we're super excited to introduce our topic soon, which I'll hand that off to John later. But setting this up and what it's all about, John and I are privacy professionals who spend a good deal of time in our own research and self-education on the privacy sector. We were both super interested in this idea of sharing the knowledge that we had been accruing independently, more broadly in a way that's conversational, informal, and engaging with other professionals. There's certainly no shortage of resources on topics related to privacy and data protection, and with the speed of the growth in the field as well as rapid changes in the legal and regulatory landscape, we're hoping that our episodes will sort of grease the wheels for other professionals' self-education journey and generate more conversation overall on this ever-expanding field of privacy. John, I'll hand it to you.
Yeah, that's a great intro, Rachel. And yeah, like Rachel and I first started talking about this when we were going back and forth, I think in a work chat about IAPP certifications that each of us were working on at the time. So our own background, so I've worked in the privacy field for a number of years. I met Rachel. She's also a very talented privacy professional and excited about the work that she's doing. So we decided to partner on this. And the way we're going to approach this is, we're going to offline kind of just pick topics in the privacy field that are interesting to us, not necessarily ones that we know a lot about. But ones that are interesting, and then we're just going to go and do our own independent research and see what we find out about that subject and come back together and talk to each other about it and just kind of record it. So hence Privacy Chats with John and Rachel, or Privacy Chats with Rachel and John, however we go. And it's, in a lot of cases, we're not even going to know what each other has found in our research. In this case, we kind of do, because this is our second recording of this. So the approach is we're going to do independent research and come back and talk about it. And why don't you introduce yourself, Rachel?
Awesome setup. And thanks for the pass back there. Of course, my name is Rachel. I'm a privacy professional, and I am early in my career, but not too early to where I haven't, accrued my own little cohort of knowledge and certifications in the field. But there is a lot of context and there is a lot of nuance that isn't practically exercised every day, but really does help put the larger picture of what we do as professionals together and give ourselves a more meaning behind the purpose why we do what we do. So as a formal disclaimer as well, we're both employed and we both work closely together, but everything that we discuss here is meant to be a representation of what we found and what we've discovered through our research from various sources, the IAPP, Wikipedia, and Google. Now, it's not necessarily everything a reflection of the opinions of anyone we know or our employers, our people we talk to, such as siblings and our neighbors. And it also shouldn't, be taken as any sense of kind of political direction or opinions here as well. A lot of what we'll be doing is recapping what we found, which do sometimes have political undertones to it, but this is meant to be a very objective sort of re-explain in the summarized version that we kind of hold up in our heads. Do you have anything to add there, John?
No, that was a great way of describing it. I love the disclaimer, because we really aren't speaking on behalf of anyone else. I know that we're both very passionate about the subject of privacy, so I suspect that our opinions about some of the things are going to leak into the conversations, but in a good way. I think we're going to avoid some of the hot button political topics, for example. So should I go ahead and introduce our first topic and get into it? So the topic we're going to talk about today is kind of recognizing that the privacy and how it's implemented is an evolution, and things were different things were different 1 year ago than they are today. So we were wondering about the history of that. So the subject of this episode is the history of privacy. And I guess let's start off by seeing how far back in history we can go. So I'll bump this to you, Rachel, with a question about what was the earliest reference to privacy that you came across in your research?
So privacy as a concept is referred to as I've found indirectly in the laws of classical Greece, even in Jewish law, even contained elements of similar, objectives of privacy in the Bible and even the Quran. As a legal formula, of course, privacy was introduced not only until the about 19th century. However, we can trace its cultural origins as early as ancient Greece, which is the earliest I found, at least. And this was relayed in laws, again, indirectly in kind of social contracts, due to the inherent design of the political structure of the Greek polis, or those Greek city-states. Nothing explicitly mentions privacy, but it is said that certain acts of unauthorized entry into private property or personal spaces was punishable by law. A little bit later, still prior to the introduction of any focused privacy law, going away from the first Greek references and over to Europe, more toward English and the UK, we have a very early Peace Act of 1361 that included the calling for the arrest of what were called peeping toms or eavesdroppers. If you haven't heard that term before, it's familiar to me. But this peeping tom term was an informal way to describe someone who was secretly observing or spying on others, particularly when they were engaging in private activities or in their personal space without their consent. And this Peace Act was actually primarily a response to some ongoing conflicts and social unrest at the time between Ireland and England. But I found it fascinating that this was kind of included as, hey, this is a social no-go for us, and we recognize that in the form of this very early act.
That's fascinating, because that's just kind of a given that doing something like that is against the law today. So it's funny to think that there was a time that it wasn't against the law. Some of my research goes back to, like, just referencing the European laws. I found a reference to the Magna Carta, which has a big influence on laws throughout democracies across the world, even today. So the Magna Carta from 1215. And there was a quote in there that said that no free man shall be seized or imprisoned. And then it talks about a lot of other rights and privileges. But then it adds, or deprived of his standing in any way. So again, like you said, the Magna Carta doesn't specifically mention privacy, but taking away or holding up somebody's standing in any way kind of is a nod to privacy in some way. And then also in England, in London, I found a case in 1604. So that's, I guess, in the same era, although the one that you referenced was in the 1300s, so 300 years later. But it sounds in the same era as together. But there was a case in London, the Semaines case. I may be pronouncing that wrong.
Sounds tricky.
What's that?
It does sound tricky.
Yes. So this case was about a debtor. There was a man who owed a debt to somebody else, and clearly wasn't paying it. And the man who owed the debt was staying in somebody else's house. So the authorities just broke into this other person's house to collect the debt. So this ended up in court. This was, a couple of, or I guess 400 years after the Magna Carta. And this case established the doctrine that a man's home is his castle. And I think that's a doctrine that's often referenced in case law and things like that today. So yeah, that's a kind of a tie-in with what you were saying about the European laws.
Now, John, was that your earliest reference to cultural or like legal references to privacy, or does it go even further back than that?
So the earliest actual reference, which isn't a law, well, I guess it would be a cultural thing, but it goes back to the Hippocratic Oath, and I've got that dated around 400 BC. And my understanding is that the Hippocratic Oath is attributed to Hippocrates. Some people, I think, wonder if Hippocrates actually wrote it or not, but it doesn't matter. He gets credit. So the quote, there's a lot to the Hippocratic Oath about medical practices. But the section that's related to privacy, and I'm just going to quote it from the version that existed back then, says that whatever in the course of my practice I may see or hear, even when not invited, whatever I may happen to obtain knowledge of, if it not proper to repeat it, I will keep sacred and secret within my own breast. So that's clearly, it doesn't use the word privacy, but that's clearly recognizing that he should keep private, or doctors should keep private information to themselves, which is kind of we're going to get into sectoral laws here later on, but this is kind of a tribute to that, because this is about privacy practices very specifically within the medical field. So yeah, that was my earliest one.
Yeah, and it's amazing that these age-old concepts, these desires of humans to be able to control what they share and what's done with that information too, or control the content that they wish to keep undisclosed at all, is being contextualized over time across different cultures. I found that privacy is generally defined as this desire of people to freely choose the circumstances and the degree that individuals want to expose their attitudes and behaviors to others. And this modern concept of privacy is continuously understood under the context of human rights, really. Most informal definitions that I could see too boil down to a single concept embedded in philosophy and law and ethics, which is personal autonomy. Personal autonomy, at least to me, is very heavily intertwined with concepts like individual safety and control and independence. So, of course, in practice, all these concepts are influenced by social and cultural and technological contexts that will vary widely across situations, which finally brought me to this understanding of a term called privacy pluralism. And privacy pluralism recognizes this very concept, that individuals and cultures and societies may have different expectations and needs and priorities when it comes to privacy, and those should be recognized holistically.
So thank you for that. So that's an interesting take on it. And I remember when you and I were first talking about some of these privacy principles, was as we were both looking at IAPP certifications, and I know at least one, maybe more of them, talks about that, the contextualization of privacy. And there's an academic who's written some articles about that, Helen Nissenbaum, and she's is specifically referenced in some of the IAPP training. And essentially that's what she talks about. And she wrote, of one of her academic papers, she wrote that generally when the flow of information adheres to entrenched norms, all is well. When violations of these norms, however, often result in protest and complaint. And the essence of that is like the analogy that I like to use is that we do have an expectation that our healthcare provider is going to send information to the pharmacy. They may also send information to another healthcare provider, but that's going to be really different types of information. Like if they get into detailed records about what your medical diagnosis is, that's not something that your pharmacy needs to know. It is something that a different healthcare provider might need to know. And the same is true if we were to look at business. Your car mechanic, there's very little information that they might need to send to somebody else, but if they find private information in your car and they were divulging it to other people, so that would be a clear contextual norm, I guess. So that's kind of a tribute to what you were saying about the contextualization of privacy.
Absolutely. It brings to mind concepts of, purpose and use limitation too, if it's
Sure.
less maybe critical health matters, but, business content and, from a consumer's perspective, things I choose to share with platforms, I should know what I'm sharing and what's being done with that, and trust that the additional, little identifiers or more semantic information about me is not being used in a way that I wouldn't expect to be, provided for the service or that I sign up for at the time. So I can see the overlaps, even across the sectors, but I understand that it does get more complex depending on the scenario you're looking at. Something I wanted to bring attention to with relation to the history of privacy that I think was a really pivotal moment that brought attention from, I don't want to say, common people, but those that weren't really in the legal field and maybe weren't, making the key decisions that, had led to the older references, such as the Greek law and the Magna Carta, as you were talking about, was in 1890. So we're jumping ahead on the timeline a little bit.
Sure.
We had the Right to Privacy published. It was an article by Samuel Warren and Louise Brandeis. Correct me if I'm pronouncing that correctly, because I have read it a bunch, but never had to say it out loud. Yes. So they published in the Harvard Review this Right to Privacy article that really set forth the essential definition of privacy as the right to be left alone. This was triggered in the day, remember it's 1890, after Warren, one of the authors, was annoyed that the newspaper seemed to be, quote unquote, having a field day during the occasion of wedding a daughter. I don't know if this was his daughter or if he had observed it through his own reading of the newspaper, but he was quite annoyed that such a private, occasion would be blasted to the news after, the advent of more printing technology made this, an accessible thing to reach households. This existing concept, of privacy really focused on property. So what was missing in the legal torts and laws that Warren and Brandeis had analyzed was that there wasn't really a framework sufficient to, identify the non-tangible or the non-property aspects to people's right to keep or not keep something. Your, territorial privacy right, or the right to be left alone within your own space and the right to not be bothered within your own space was likely well understood, or at least were contained in laws. But this idea that when you're out and about and you're in public, whether that's something you desire to be put into the news and through the printing press or not, that doesn't give you blanket permission to be put there just because you're leaving your home. They identified there was a huge gap in that kind of component of personal autonomy extending outside of just your property, and more so looking for a way to define privacy in a way that can allow individuals to participate in the space, in the open space, the common space, safely, and develop their personalities and form their relationships and engage in self-expression without this, fear that everything is being monitored and watched without their knowing.
Yeah, I mean that's a great find. The Warren and Brandeis article, I think, is one that is a pivotal moment in the evolution of privacy. Any kind of research that anyone does about privacy is probably going to unearth that. I've run across it a number of times in my career. I remember reading the whole article way back when, and even since we were doing this research, I bought my copy of it just to kind of have on my bookshelf as a memento, I guess.
Yeah.
So I don't know what that says about me as a privacy professional, but those are the types of things that I collect. But I think that the essence that I got out of the article was kind of recognizing that there were laws that in their essence they said that people should have that right to privacy, but it wasn't written in the law, and they were pointing out that was necessary, that it needed to be. And I think it's also interesting that article, like you said, I think was published in the Harvard Law Review, but it's often referenced in case law. And I don't know, we're not lawyers, so I'm not sure if that's unusual. But my interpretation or perception is that in case law, they would generally be citing other cases or other laws or things like that. In this case, they're often referencing just an article from the Harvard Law Review, but clearly has had an impact throughout the history in privacy.
Absolutely. I'm going to pause us right here. I have a question. So I want to go back to the topic of territorial privacy that I mentioned briefly earlier with the Brandeis case, or the Brandeis in Warren Law Review article, which is this concept of there being different types of privacy as recognized categorically. Now the IPP recognizes 4 different categories of privacy, and those are information privacy, so the control and the protection of personal information, and the right to determine when, how, and to what extent personal information can be collected, used, or shared by others. What I mentioned earlier is the second one being territorial privacy, which repeating myself here a bit, but it is that concept that relates to the reasonable expectation of privacy over their personal spaces and their home, workplaces, and other physical locations where you have a legitimate expectation of privacy. The next is, of course, communications privacy, so the protection of our confidentiality and security of correspondence, and this is very broad as it needs to be, capturing physical mail, phone conversations, text, email, really any form of information exchange and messaging between two individuals or two entities. And finally, we have bodily privacy, which I know will be relevant soon here in our conversation, which is this, right to control the access to an individual's own body and personal space, free from unwanted, intrusion or interference in that, in the decisions of what to do with one's body. Of course, this is really relevant today as medical treatments and reproductive choices. Bodily functions are, like you said earlier, a hot button debate and how we treat this in more of a legal framework. But that it is a very strong concept in privacy because it's the right to control and decide what you share as it has an impact on your health and your choices as an individual.
Yeah, for sure. And I can't think of anything more important than having control over oneself. And bringing it back to the post Brandeis era. In this case, I thought was very interesting, so I wanted to talk about it. And I don't know, it seems to straddle the bodily privacy and territorial privacy a little bit. But there was a case in the early 1900s, I want to say like 1904, of a woman whose picture had been taken of her. I presume that picture was taken out on the public, so it gets to the territorial privacy. But it was a picture of her, and I think the technology at the time was lithographs rather than pictures. But her image was placed onto, I think, either posters or maybe packaging material for like a flour mill. And then these things were reproduced and put all over the city. I think this happened somewhere in New York, upstate New York. And she didn't like it. She saw these things and saw her image being spread all over the place, recognized it was her, and she didn't want that. So she sued the company, which is probably something that couldn't have happened before Warren and Brandeis, even though I'm not sure any laws had actually been passed by then. But she sued the company, and originally she won, and the company appealed it, and in appeal, the ruling was overturned. And one of I forget the actual quote, but one of the judges in the appeal basically said to her, "You suffered no harm here, and you should be honored that this company would, take your picture and put it up in like this. You suffered no loss because nothing of material value was taken from you." So my understanding is, as a result of that, there was a big kerfuffle in society at the time of recognizing that was just wrong, that she actually really did have a right to control her image. So I think that the result of that was other laws being passed. And I think it's interesting that in 1904, this woman stood up for her rights, and she was able to, bring about important change.
Absolutely. And I love that tie into the right to privacy article, because her story sounds very similar to what I believe Brandeis had actually observed himself. And it was almost I don't want to say an exact copy-paste scenario, but she was really living the concern that they were touting at the time with the new technology of the lithograph. And I mean, this may seem archaic to us, but it was really that first way to mass produce images in the sense that didn't require, a 40-hour painting and redistribution through that means alone. But for the first time, I imagine we were, your self-image was extended outside of your actual physical location in your own interactions. And that's got to be something scary not to have your control over, especially when it's, something you didn't expect.
Yeah, I think that's a thread that we've seen throughout a lot of this history that both of us have looked at, is that the laws at the time seemed to be responsive to technologies that were evolving. And I know, like in my own research, it seemed like the early American laws, like post-Revolutionary War era, the laws were focused on protection of the mail. So I'm picturing the U.S. mail or the Pony Express, or however people sent paper correspondence from one to another. that needed protection. I'm not sure what it was being protected from, but clearly something was happening. That data that was included in these letters that were going through the mail needed to be protected. So that's what a lot of the laws focused on then. And then during the 1860s, there was a lot of references to laws that were passed during like the Civil War era that were protecting wire, like communication over wire. So wiretapping laws started to come on the books to protect communications during the Civil War, which that would have had a huge implication on the war efforts themselves. If one side can spy on the other side by essentially tapping into their communications. Although I have to wonder how much the laws that were on the books were being recognized by your adversary in a war. But however, it's relevant to this conversation that those laws started to show up on the books in the mid 1800s about wiretapping.
Oh yeah, absolutely. And I mean, I'm thinking back a little bit to the tie-in with I'm pivoting a little bit back to the Brandeis case, but the there's also another element besides this surprise or this expectation that someone's listening to you or they're observing you without you physically being there. And that's with the accuracy of information. If you don't control the information or your likeness or your communications and the visibility of those, you have no control and say over what is being represented is actually accurate. At least in the case of this wedding that the authors had observed that led to the right to privacy article. There was a quote I really love because I feel like it's relevant today, which is, "Gossip has become a trade that's pursued by the media with no regard for social norms or cultural etiquette." And a little bit further past that that quote, they kind of expand a little bit to cite this problem of fake news as a result of this intrusive scenario. I imagine even then you could send a lithograph out to many people that had some information behind it that was completely inaccurate, maybe text below it, who knows how that works, but
Sure.
it is something that they recognize as a possibility.
Yeah. So going back to the Brandeis era, there was another case that I really liked. So it was a, and I'm not going to get into the details of the case itself, but there was a ruling in the Georgia Supreme Court that was the first one that I found that really got into the specifics of the right to privacy in common law. So the quote that I like from it says that, and this is from one of the judges on the Supreme Court at the time. It said that one who desires to live a life of partial seclusion has a right to choose the times, places, and manner in which and at which he will submit himself to the public gaze. Subject to the limitation above referred to, the body of a person cannot be put on exhibition at any time or at any place without his consent. It therefore follows from what has been said that a violation of the right of privacy is a direct invasion of a legal right of the individual. Which gets into, like you mentioned, the Peeping Tom cases from England in the 1600s or something, through the case of Robertson in 1904, I think. So I think this starts to address it. But it's interesting that the timeline, while looking so far back, those dates seem very close to each other. But it took from 1890 is what we said that the Brandeis article was published. This quote from the Georgia Supreme Court was 1905. So it took 15 years for them to get there. But at least they did, and we've come a long way even since then.
Absolutely. And it's, of course, following the advent of technology, right? And even the means to kind of identify these issues in mass and place into law. I mean, it always is this push-pull of need and response, and unfortunately it was still even slower than it is kind of responding to those recognized issues and the resulting legislation coming out of it. But we got there, and who's to say that we would really be in this industry had technology not exploded the way it did.
Yeah, for sure. So we're stuck back in, so we're in the early 1900s. So let's bring it forward some and see, things changed over, the early 1900s. So do you have anything that you wanted to reference from, let's go into the mid 1900s and see what you got?
Absolutely. I want to jump into a case from actually 1967, Katz versus the United States. So this is really coming off of your comments about, wiretapping being an issue, and of course, as a few decades go on, we're all now using the telephone, and it's available, across the U.S. and I'll keep it focused on the U.S. Scenario right now with this case, but Katz versus the U.S. This involved a Charles Katz, who was a sports bettor back in the 60s who frequently used public telephone booths near his apartment in LA to communicate handicaps to what were called bookies located in Boston and Miami. Now, given this activity, the FBI was really interested in investigating into such gambling activities, and they felt that they could just record his conversations through a covert or unidentifiable listening device that was pinned right outside of that phone booth, in of course, an attempt to indict him for sharing illegal, betting practices or wagering information. Katz was tried for illegal betting practices with this evidence. However, he rightfully pushed back by arguing that the FBI didn't actually have a search warrant for this, and that the recordings were made in violation of the Fourth Amendment, and that the evidence that they had collected shouldn't be admissible in court as a result. Of course, they didn't recognize this, and Katz attempted to appeal this decision, and it ended up going all the way up to the Supreme Court. In doing so, the U.S. Court of Appeals ruled that because the device wasn't physically in the phone booth's walls, there was no search that needed to take place anyway, and therefore didn't require a warrant at all, and the evidence was permissible. There was a lot of focus placed on whether this phone booth that Katz was in was considered a quote-unquote constitutionally protected area. Katz rightfully pointed out many times during this case back and forth that it was a major deflection of the actual problem at hand, which was that he didn't know he was exposing this information in public, right? He assumed this phone booth was contained to him and the recipient on the phone on the other side. So it was a contradiction to Katz, using the Fourth Amendment for this type of protection, given that he didn't have his own space protected as he had imagined. That really just boils down to the expectations and kind of the application of this, adversary trying to nail him down for a crime and him, doing his business.
So the outcome of that, so just to be clear, the Supreme Court ruling in Katz was that was an unreasonable seizure or not?
It was. I believe the outcome was that it I actually can't remember.
It was. No, I think it was. I think you're right. But yeah. I thought it was, the reason I was asking that is it's interesting that even though they found that was an unreasonable search or seizure, that they allowed the evidence to stand in the case because it was outside of the phone booth, which is really interesting. So in response to that, because I think I knew you were going to talk about Katz, and there was an earlier case, so going back into earlier than that. So there was a case in 1928. It was, again, the United States. It was Olmsted in this case versus the United States. And in this case, it was a bootlegger, so another criminal, but somebody who was being charged he was found guilty of prohibition violations, which obviously aren't against the law anymore because prohibition was overturned, thankfully. Sorry, I know we're not supposed to have opinions here, but I'm happy.
Yeah.
Anyway, so in that case, he was talking on, I guess, the phone with, co-conspirators in his prohibition activities. And the feds went into the basement of a building that he worked in, where he had an office, and they essentially wiretapped his phones, and they used that as evidence against him. So in that case, the Supreme Court found that this was not a violation of his rights. It wasn't an unreasonable search and seizure. So it's interesting that there's, even at the Supreme Court, there's this kind of ebb and flow. So these two cases are very similar. Olmsted and Katz, like one guy was talking on a payphone, the other guy was talking in his office. Both of them were criminals at the time. And the feds were, listening in onto their telephone conversations. So, I think it's good that we're trending in the right direction, that, at Olmsted, they said it wasn't a violation, but in 1967 with Katz, they said it is. And I think Katz is the precedent that stands today, because I don't think the government gets to do that, although they've given themselves some exceptions for international things, but we won't get into that with the FISA courts and stuff. Anyway, really interesting stuff.
Yeah, and if I can wrap us up real quickly with what at least the Katz case gave us that still stands today, which is this two-part legal test. Again, not a lawyer, relaying what I've learned, but a two-part legal test on the expectation of privacy with respect to the Fourth Amendment primarily. And this thought is that the expectation of privacy is activated anytime a person has an expectation of privacy that is subjectively and objectively reasonable in the eyes of society at large. So it really enumerated after Katz that the interpretation of the Fourth Amendment should be protecting people and not merely places. The subjective component of this assessment says, did the person exhibit an actual subjective expectation of privacy? Can you really demonstrate that they kept the evidence in a manner designed to ensure its privacy, or basically is it in plain view? Am I going out and holding a sign with my social security number on it, or am I keeping it guarded in my home and not blasted out for everyone to see, right? And then the more objective component of this is the expectation one that society is also prepared to recognize as reasonable. So from an outsider's perspective, would most people also agree that within a phone booth, those conversations are meant to be kept private? And so this was cool because this was at least a positive impact of Katz versus the United States, where previously law enforcement practices that weren't within view might have been using evidence that wouldn't be otherwise permissible outside of this two-part test. The bad news is this is still a pretty ambiguous application. It's not in any way a hard rule, even though there is a subjective and objective nature to this. It's really not. It can't stand up to the very nuanced scenarios that we have, especially in the digital case, in the digital environment that we exchange information in today. So I imagine, as more time goes on, it'll be harder and harder to consistently apply this two-part test, specifically under the guise of, the reach that law enforcement can have to actually collect evidence to indict someone for a crime.
Yeah, it's interesting that those nuances are there because, like that term, reasonable expectation of privacy, and it's a doctrine that I think stands, throughout law today. But how do you measure it? And you did a good job of summarizing it. It reminds me of I don't know what the case was, but there was a Supreme Court justice was quoted, and I think they were talking about pornography. And his answer, I think they were talking about what's the definition of pornography, because art has a lot of nudity in it, and there's medical journals, are those things pornography? And the quote from him at the time said something like, I don't know what it is, talking about defining it, but I'll recognize it when I see it, which is an interesting nuance about, I guess in that case, pornography, but it's a similar thing to this reasonable expectation of privacy.
Absolutely. So going away from Katz, because we're still in the 60s, 70s-esque era of, privacy in law or indirectly in U.S. culture at least. What else do we have after this? Do you have any direct tie-ins from Katz or even from this era in particular?
Yeah, so going back to what we said earlier about the privacy laws throughout history seem to have been tied to the evolution of technology. So what's the next technology? So in the 1970s, the equivalent to the pieces of paper going through the U.S. mail or the Pony Express was the evolution of the digital age and having computers and databases. And, for the first time, they could take information and replicate it and duplicate it and send it all over the place through networks. So that was when they started to recognize the need to protect data. And I'm completely off track here. So getting into the 1970s, things started to get interesting about rights about bodily privacy. So we're all very familiar with Roe versus Wade, which I'm pretty sure was passed in 1973. It stood for 50 years and was overturned just last year. Clearly, we're not done with that. There's a lot of talk in our society about it today. But that was recognizing a woman's right to her own body and what happens to it. And people tend to focus on the other political aspects or something of Roe versus Wade, but in its core, Roe was a privacy law that it protects women's rights to have control over their own bodies. And similar to that one, there was a case just before that in Griswold versus the state of Connecticut, which granted women the right to use contraceptives, which it's amazing to me that before Griswold, that right didn't exist in laws. So, that was a time when we started to get into a lot of those bodily privacy laws.
I want to talk quickly about a new concept that I had learned that seems connected to both the Griswold versus Connecticut case and the Roe versus Wade case, which is this concept of penumbra rights. And I'll say again, not a lawyer, so sharing what I've learned in an effort to research this episode. But this term penumbra rights refers to this concept of implied rights that are derived from more explicit rights maybe stated through the Constitution. So in this case, although the right to privacy is not explicitly mentioned in the Constitution, it can often be referred to, inferred from the text that is contained in the structure of the Constitution as a whole. There are, of course, explicit protections that involve the First, Third, Fourth, Fifth, and even Ninth Amendment sometimes that create this zone that blends together, kind of relevant privacy norms, or some of the norms that we'd even called out earlier in this episode from older references to it. But there is an undertone that this right to privacy should be encompassed within the explicit rights stated in the Constitution, such as ones, with the what's being able to be decided and communicated in with respect to, a marital relationship. And of course, in the Griswold versus Connecticut case, it was, a very relevant topic to, actually come to that decision.
Yeah, and I think that whole concept of the prenumbral rights is interesting in, kind of recognizing that if people have that right, whatever those rights might be, it's important to actually encode that in law and not just have it sitting out there that the law, kind of implies that you have it. Because, we found, and again, we're not lawyers, but there's plenty of examples through history of implied rights not being honored, that, whoever's next in power can just ignore those. So we need to get them actually encoded in law. So, at the same time, that era of Griswold and Roe was also kind of the introduction of, computer systems and networks. It was the first time that that information now could be duplicated and sent faster across the world instead of, so the new technology at the time needed to have protections in place for it. So that started kind of an era of, a lot of new protections. And the first one that I found reference was fair information practices that were put together by a group from, I think it was the Department of Commerce that put this together, of really just kind of outlining what are the expectations of information privacy with digital systems, which, a lot of the work back then, even starting, so FIPS was in 1972, served as kind of foundational for a lot of the laws and standards that exist today.
Yes, and something close to that I recall from some of the IPP training that followed shortly after these FIPS, the Fair Information Practice Principles, was in 1980 when the OECD, or the Organization for Economic Cooperation and Development, had also proposed very similar privacy guidelines to the principles that were outlined in the FIPS here. So FIPS includes concepts such as notice, choice and consent, access and participation, integrity and security, and the enforcement and redress aspects of these violations here. And of course, these are all guidelines. But I found that it's fascinating that these two cropped up at very similar junctions, given that they had both. Sorry, my Katz sneaking in behind me here.
It's okay.
Given they were both responding to the technology at the time, and I imagine there was kind of a race to address some of the concerns that were cropping up all over the place. Now the OECD guidelines, and of course guidelines, not necessarily laws quite yet, have these dovetailing and overlapping themes contained in the FIPS, which, at a high level, these are collection limitation, in all principles, by the way, data quality, purpose specification, use limitation, security safeguards, openness, individual participation, and accountability. So a lot of things that actually stuck out to me when I was listening to our earliest cases of, either a lack of privacy and the need for it. There are things, use limitation, having purposes other than, the reason the data was collected in the first place. It's important, after we had identified that the mass information sharing with the printing press technology and the lithograph, like I was saying earlier, there is always a concern of representation there. And things like the purpose specification principle also kind of covers this, where, what I share with you or what I share with others should be understood to be very limited for the expected purposes that I see. See that relevant in some of the mentions of the cases earlier with bodily privacy, right? In the medical field, I have expectations for what my doctors need to know, but I don't have expectations that they'll share that without legitimate reason that doesn't otherwise support my treatment or informing other medical practitioners in order to bring me that treatment.
Yeah, for sure. So that kind of brings us into the whole concept that's huge in the United States today of what's referred to as sectoral laws. So if we look, and this is kind of a sneak peek at a future episode that we intend to talk about, but things are a little bit different in Europe. And in the United States, a lot of the privacy laws are what we call sectoral. So I'll go back to 1972. And, again, this was right after FIPS and recognizing that, a lot of data in databases and what can be done with that and that it needs to be protected. So in 1972, the FERPA was passed, which is a law that protects essentially data about students in educational settings. In 1978 was the FISA law, which gets into kind of the international transfer of data. 1996, we're all very familiar with HIPAA, which is really about insurance, and but it has a lot of privacy practices built into HIPAA. But it is is very specific to the healthcare industry. So a lot of people will cite HIPAA as being authoritative over privacy practices, but they're limited. And since it's very specifically tied to insurance, somebody gave me an example one time about HIPAA that if you have a doctor who chooses to not accept insurance or Medicare, so their patients pay them directly without any insurance, that because of that healthcare provider is actually not bound by HIPAA. So technically they could take your private medical information and not treat it with the same level of protection as you would expect from other healthcare providers because of HIPAA. Again, I'm not a lawyer, so don't at me in comments if people have them about this, if I'm wrong about that particular part of it. But anyway, so that was a whole lot of laws that were passed in those 20, 30-year period. And a lot of them did abide by the principles that were set out in FIPS. And you recognize the OECD in 1980, which I think today serves as a universal standard. If you look at privacy practices across laws around the world and practices within individual companies, you can almost see FIPS and OECD exactly, almost word for word, in their privacy principles. So those stand to today as really kind of authoritative over our practices, which I think is great.
Right, and something that is interesting about those guidelines is that they're coming up in being a bit dated, if you think about it. It's going to be coming up to 50 years in a few years. And I mean, technology changes more rapidly than sometimes I can keep up with especially with regards to the means of sharing information in the formats that it's distributed in, and really the speed and the protections behind it. So I always wonder when I look back at those frameworks and think whether they're really sufficient to cover all the concerns today, which could be its whole other episode. But they were very generalized even for the time, and that was still before the mobile phones, IoT devices, and even before some, maybe not technology specifically, but platforms that encourage sharing and accessing and exchanging information about others, less directly in sort of a business context, but as somewhat of a utility in the sense. Most people I know have a Facebook or Snapchat or an Instagram or something that keeps us connected 24/7. So really, are these principles encompassing the advent of those technologies, or is there a new framework that we need to come up with in this continuous cycle of learning, using, and improving based on the risks that we identify as a society?
Yeah, it's huge, and I wonder. So maybe I'm going to push back on you a little bit about those standards being antiquated, because it is true that there's such a rapid growth of social media and artificial intelligence and machine learning, and we don't, it's always this catch up that you reference. But in that there's a gap of time between the new technology coming out and us catching up with and having the right laws to protect it. And I think the thing that fills that gap is those foundational privacy principles that, if we go back to the reasonable expectation of privacy. So because of what exists in previous laws and previous standards, that when I get into a new technology, then my reasonable expectation is really based on the foundation that was set before it. So I think that there's an opportunity for us to kind of use both of those. Let's use our foundation that was established, and you could say it was in the early 1970s in FIPS, or in 1980 in OECD, or in 400 BC by Hippocrates. But the establishment of all of those, and somebody like Robertson, who stood up for her rights to not have her picture taken or used, published, kind of brings us to where we are today. And I feel like I'm rambling a little bit, but it's an important problem that things are developing quickly, and we need to rely on what we know and what we're developing to protect them. But yes, we have a lot of work to do to protect people, which is what privacy is all about, people and their data, as new technology emerges.
Absolutely.
And it's cool to be a part of that.
Yeah. I was just thinking it's really sweet to know that your career is really part of closing that gap. There will always be kind of a learn and understand and respond to new technology in their capabilities, especially when these threats are not anything like we've seen before. However, I think the important piece of that learning and growing and reacting cycle is actually taking account of what's going on and communicating about it, and having others that are less either technical or less informed in like the privacy space as a discipline understand the implications of what they're using, and at least know to be, well, I say warned, that we have to learn these things the hard way, and we do ask companies for accountability, but research is so quick, and there are some really, really positive benefits out of things like artificial intelligence and machine learning in particular, as it's a very prevalent topic today, even in the world of privacy, that we don't want to discount. We don't want to stifle these innovations in the event of preventing the complete unknown. But we do have to be very timely with addressing these concerns and finding the safeguards and giving accountability behind those that use and create and actually change these technologies to make sure that they're truly for the betterment of the world without sacrificing any inherent human rights that we've developed over the last 100-some years.
Yeah, for sure, and to try to do that in a way that helps these technologies to grow, because most of them, I think, are technologies that really do improve things for us in our lives. So I don't think privacy is about stifling that, but it's about encouraging it in a way that's beneficial to all of us. And I think the way a lot of that is happening is with laws. So I referenced a lot of the sectoral laws, which aren't comprehensive enough to cover everything. So because of that, there isn't a comprehensive privacy law in the United States right now. So to fill that void, a lot of states are now, enacting their own state privacy laws. So just looking at a chart here, So right now, by the end of this year, we'll have 5 states, Virginia, California, Colorado, Connecticut, and Utah, with comprehensive privacy laws. A couple of those, Colorado and Connecticut, just became enforceable on July 1st, so just a couple of weeks ago. Oh, I shouldn't have said when we're recording this.
It's okay.
It's okay. And then Utah's law will become effective and enforceable on December 31st. But that's going to create a problem, because if we end up with 40 or 50 different privacy laws from each state, that's very, very difficult for companies that operate across the country to have to abide by different laws in different states. Now, hopefully, most, won't be all, but most of these laws are going to kind of follow the template that was set out in, like we said, FIPS and OECD. But each of them are going to have their own little nuances that are going to be difficult for companies to keep up with.
Absolutely, and when you were talking about the difficulty of really adhering to each individual state's rules to that end, that's before we even think about the international cross-border data transfer. I don't want to call it problem, but phenomenon of different countries having different cultural expectations for what law enforcement should be able to access and use for the purpose of keeping their citizens secure. And that delta is really wide, and like we touched on throughout this podcast, really depends on the kind of norms in place already and the existing kind of political frameworks in place, and then the expectations of their citizens too, which is, maybe push back on it sometimes, but the response, to companies needing to adhere to these things, it's typically a globalized operation, right? Most of tech is in the internet is not centralized to one region, so it becomes a problem for everyone, not just one single country, to need to kind of respond to the right to access in what other jurisdictions think is okay to share and transfer data with response to the company that is actually generating and processing that data and the access rights that they give their government in that jurisdiction. But I'm getting a little ahead of myself here. I know we talked a lot about the U.S. today and the history of privacy in broader than the U.S., but in the future, we're going to do somewhat of a specified topic on the European landscape of privacy and the developments there, both in law and both more informally through guidelines and expectations, and our understanding of how we came to things very large, such as the GDPR and the e-privacy directive that we have today.
Yeah, for sure. And so I'm looking forward to that. I've already started doing a little bit of research into it. So yeah, GDPR clearly is something that's foundational for privacy laws across the world, and will continue to be. So I'm looking forward to that. This has been great. I've really enjoyed putting this episode together with you. I've learned from the research, and I kept getting dragged down into rabbit holes reading about these different cases, and I've learned from you and some of the research. So I've enjoyed doing it, and I'm looking forward to more. And if anyone actually watches this, thank you for spending time with us, and we hope that you come back for our future episodes.
And of course, I totally agree. This was such a learning experience, and it both literally and just the activity of creating a podcast for the first time. I think the act of researching can be the easiest and the hardest thing to do because of those rabbit holes, right? We want to go into depth with everything, but we are limited in our focus for our topics per episode, and do want to keep it a bit more free flowing. But that was exciting for me. I couldn't stop with the research, and it was the most difficult part to keep myself focused, honestly. But that's what more episodes are for. So. Thank you, everyone, for joining us, and we'll see you next time on Privacy Chats with John and Rachel.
Rachel and John.
Rachel and John.